Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is September 21st, 2017. This is our bi-weekly community conference call every other Thursday. I did not mark any questions as frequently asked questions today. I felt that most of the questions were uniquely limited to their own facts. So let's get started with question number 1. This is from Pot Terp 385. I'm a full-time employee at a company. I did my bachelor's from India, came to USA for master's, converted to H1B, never worked in India. I have no work experience from India. 8 years of experience in technology, lead software engineer, 2014 priority date. If I get promoted as a manager, can we file EB1? No. For EB1, you must have worked outside the United States for 1 year as a manager or executive for EB1C, as a manager or executive for a branch, parent, daughter, sister, affiliate, etc. of this company. So just because you got promoted to a manager does not make you qualified to get an EB1C. For EB1C, out of the last 3 years immediately preceding the application, and there are some wrinkles there, but the bottom line is you've got to be outside USA for 1 year working for a related company, a company related to your American company. Press *5 on your phone if you have a follow-up question. No new questions, please. *5 if you have a follow-up question. Okay. Ravi Kumar 003 says, F1 OPT extension is good till May 2018. I'm working for employer A. My H1 is pending, but current client is not willing to provide a client letter. Just as a matter of comment, remember, end client letter is not the only way you can prove the things that need to be proven. There can be other things such as agreement, contract between the employer and the end client, or some kind of a work order. There are different things you can use. So let's say your employer now wants you to move to a different client. So there are more number of chances for H1B approval. See, here is the problem. You've got an H1B currently pending, not approved. You want to file an amendment on top of a pending H1B, and this is a quota H1. This is not an H1 you can fool around with and still be comfortable in the knowledge that you are not subject to the quota, even if your case is denied. Here, if there is any problem in the chain of events, you could lose your place in the quota. So, what is the current thinking of the government? What was the old thinking of the government? It's a little confusing. The old thinking of the government was, if you have one case pending, an H1B quota case pending, or a transfer or an extension pending, and while this is pending, your circumstances change, you can file an amendment and they will approve the amendment as long as the original case was approvable when it was filed. In other words, it had nothing missing. So you would have to potentially prove two cases inside of one. Now, it appears to be a little bit more doubtful. I was looking at the January 17th regulations. Was it yesterday? Yeah, I think it was just yesterday. And it appeared to me that government is saying now that if you have a series of cases pending, like a daisy chain or a domino, then unless all of them are approved, the terminal one or the last one that you filed will not be approved. Now, if it was just a case of change of status or extension, it'd be much easier to manage. But when you have a quota case, I'm not quite sure how it would play out. So the old thinking of the government was, as long as the first case is approvable when filed, the fact that you're filing a second case during the life of the first one is okay. I'm not so sure anymore. Please have your lawyers look into this in a little bit more detail. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's go on to the next question. EB3, EB2 2016. So you've got a bachelor's degree, which is a 3-year degree from India. 10 years of experience, but there's a gap of 7 years between bachelor's and master's. You completed your master's in 2008. There is a technical problem with your filing, and normally what we do is, when we have a 3+2 combo, we try to keep track of the latest thinking of the government. Up until about a year and a half, 2 years ago, their thinking was, you can combine 3+2 to be equivalent to a bachelor's degree. And as long as you have 5 years of experience past your master's, you should be able to qualify for EB2. And the way we would prepare the labor certification, the PERM application would be that even if my EB2 is denied, my EB3 will be approved. So we drafted it in such a way to show the government that, if for some technical reason my EB2 is not acceptable, you will give me my EB3. I don't know how your labor certification was drafted. So I can't really tell whether you'll get an EB3 approval or not. I think the better thing to do is to file a new PERM. That is the smart thing to do. Because by the time you file the second PERM, if the first one gets into trouble, you can file an appeal. While the appeal is pending, you can keep getting H1 extensions. And remember, you can file for an extension 6 months ahead of time. So even if the appeal stays pending 7-8 months, you might be able to get 2 H1 extensions out of it. In the meantime, the second PERM that you're filing will then become the basis for subsequent H1 extensions, even if your appeal fails. And appeals are likely to fail because only about 2% appeals are successful, and this is a difficult case to win anyway. Not on the facts that you have described. If it has been drafted in such a way to understand the current thinking of the government, and it does change, their thinking doesn't remain constant, unfortunately. And keeping in view the fact that if my EB2 fails, I should have enough room to get EB3 approval. In those cases, I'm more confident, but here I don't know what's going on. Therefore, second filing is a good idea. File second PERM. Star 5 if you have a follow-up question on this. Okay. Fams Naz says, my son is a US citizen living in USA, wants to apply green card for his wife who lives abroad. Where should he file the I-130? As far as I know, ma'am, you should double check this, of course, in the I-130 form instructions, as well as online on USCIS website. To the best of my knowledge, it should be filed. It can be filed outside also, depends upon the rules of the consulate, but you can file it always within USA, because I-130 is his application. It is not her application. It is connected to him. So he would file wherever he is living. Star 5 if you have a follow-up question. I want to also add that some consulates will allow you to file abroad, especially if they have a USCIS office in that country. Like India has this rule that if you have lived there for X number of months, then you can file your I-130 in India. So look at the local regulations or rules. These are not regulations, local rules in the consulate where he can file outside USA. But inside USA, definitely there is no problem. Going to Indu 123. So she has an H1B, which is valid from September 2016 to August 2019. But she's going to have a baby, can't travel till October 2018. Well, I have a problem because it can't be a 2-year pregnancy. I can understand that you've got pregnancy followed by some time that you can't travel. So covering all that, if you have enough of an explanation why you cannot join, what your personal reasons are, and two, you can confirm that the employer is holding the job open for you. In fact, I had a consultation today about this. As long as the employer can, in good faith, say they are holding the job open for you, you can come anytime before August 2019. There is no time limit on H1B visas. So if you are approved for 3 years, you can fly in the third year and not come for 2 years if you have a good reason and the employer is holding the job open. The employer will have to provide you a letter that explains that the job is still open. But do coordinate with your lawyers to make sure that you've got all your explanations in order. *5 if you have a follow-up question on this. Okay, let's go on to Baltimore 80. I'm currently on H4 EAD. Before that, I was on H1B cap exempt. Green card EB2 applied, I-140 approved, 485 was not filed. Moved to H4 EAD from outside state where I worked for 4 years. Prior I-140 was not revoked. I'm exploring ways to return to my previous job. Now, because you were in a quota exempt status, you are still going to be subject to the quota unless you are going to work at a cap exempt job. So question number A, do I need to reapply H1B and join prior job and then apply for 485? No, you can file directly from H4 EAD or even H4 without an EAD to 485 as long as the employer who sponsored your green card can in good faith say that they've got a job for you before or after you get your green card approved. You can use your current EAD to join the employer also. You don't have to have an H1B. You can be on any visa and still file 485. Can my spouse revoke my EAD? Well, they can certainly revoke your EAD by getting out of status themselves. But I don't know of any direct method by which they can revoke your EAD. So if he falls out of status, or she, I'm not sure, male or female. So if your spouse falls out of status, you lose your H4 and you lose your EAD. Bottom line, you can join on your H4 EAD. You can file 485, apply for an EAD, request that a new EAD be given since you want to give up your H4 EAD. And once the 485 EAD comes in, you're good to go. You don't have to be on H1 to apply for 485 through the sponsoring employer. *5 on your phone if you have a follow-up question. Oh, by the way, you have another question. How can we help? Well, we can help in all these processes. Anything you need help with, we can. Feel free to send me an email if you have anything for us to do. help@immigration.com. help@immigration.com. Next question, DVK for good. I am on H1B visa from Jan 2011, 6 years. Wife is on H4 EAD. Both visas are good till September 30th of 2018. My perm was approved with priority date May 2014. I've gotten I-140, didn't file 485 because 2014 date is not current. 3 questions. For green card, does my employer have to reapply for perm in the new location? Well, you said they want you to move to a new location, same job title, same job responsibilities. Now, this depends upon the language of the perm. When we file the perm, we make it clear if it's a consulting position that the job can be periodically relocated. And so we file from the corporate headquarters. I don't know how your perm was drafted. Only your lawyers can answer that question. The second way this can be done is if in the future the employer intends to bring you back to the location from where they applied, you can be in the meantime, while your green card is still pending, be working anywhere. 2 ways to do this. But your lawyers need to tell you. When applying for the H1B for new location, does my employer attorney have a chance to file H1 for the next 3 years? Yeah, your I-140 is approved. Normally, they should be able to get you 3 years. The problem is when you have more than 6 months pending on the case, government has been a little inconsistent. But recently, we've been getting 3 years when we asked for that. So The next question is very, very difficult to answer. Life is to love says, sorry, I forgot to ask. Star 5 if you have a follow-up question on the previous issue we discussed. Star 5. You folks are very quiet today. Okay, let's go on to our question number 9. Entered with fake passport, stayed till 2003, left to Canada using my real name, stayed in Canada. So bottom line is this: you have a fairly serious problem in your background that there was a misrepresentation. On top of that, there is unlawful presence. So technically your green card is no good. And I'm surprised they didn't try to revoke your green card when you tried to get naturalization. I'm not at all sure I can give you any good suggestions, but I would recommend that you spend a half hour either with us or with somebody else going over your case to see if there's any possibility of helping you. I have my doubts. I really seriously have my doubts, because any attempted or successful effort to obtain immigration benefit by fraud or misrepresentation is not only a crime, it is also a permanent bar from entering the USA. And that can only be waived if there is some extraordinary, extreme and exceptional hardship to your US citizen or green card holding spouse. Waiver is quite difficult. So, got to look at that. I can't really comment based upon what you have. I think you should, we can take a look at your case in detail, or just get a local lawyer to look at your case who's experienced and see what they suggest. Star 5 if you have a follow-up question. Star 5. Star 5. Okay, this is a difficult case to handle. Not easy. Because see, another thing I'm thinking is, if I don't admit to what I have done in the past, I can't really move forward with any application. If I admit, I'm admitting to a crime, not only to just a immigration violation. I'm confessing to a crime. And that is a much more serious matter than just immigration benefits. Something to think about. Rachit V. Question number 10. I have a question regarding H1 visa stamping. Well, first of all, whether you can go with a copy of your paperwork is a question you should address to the consulate. Email them, ask them the same thing. Normally, consulate should not have a problem because they have a complete copy of your paperwork in their database in PIMS. So send an email to the consulate. And both for you and your wife, they should be able to process you without the original paperwork. Star 5 if you have a follow-up question. Star 5. Okay. So Rajat, send an email to the consulate, and they do respond to emails. Sikandar 2017 is a Nepalese citizen. He's a US citizen from Nepal. My apologies. I live and work in USA. Want to go to Nepal to get engaged. Can I file Fiancee Visa from Nepal? Whether or not the consulates will accept a local filing depends upon a bunch of variables. Send an email to the consulate. Okay, you can of course always come back and apply, as you know. Send an email to the consulate, ask them if they allow for local filing. Star 5 if you have a follow-up question. Sikandar. Okay. Next go on to question number 12. I think we're going to have time for new questions today, so good. This one is NCYS. My employer petitioned me through labor certification in 2003, EB3 other workers. I'm already out of status, not covered by 245I, so it looks like you have unlawful presence issue. Can my EB3 approval from employer who petitioned me be transferred to a new employer? Ma'am, the problem is actually much deeper than that. The problem is, if you go outside USA, you can't come back for 10 years. If you don't go, you can't get green card within USA. So, unfortunately, I don't deal a lot with undocumented people or people who are in this sort of situation. Our work is confined pretty much to extremely complicated cases or employment or business-based immigration. Family-based immigration tends to be simpler. So we take those cases, but many of these cases you don't really need a lawyer. In your case, because it is a non-professional case, I hardly ever handle these cases. So I personally feel there is no easy way out. Now, if you have a genuine marriage to a US citizen, that takes care of all your problems. But don't get married just to get a green card, because that is a felony. You can go to prison if you do that. Okay? For a genuine marriage, that would take care of it. *5 if you have a follow-up question. NCYS. *5 on your phone. Press *5. Okay. Next question is Chandi K. I'm an Indian, L1 visa, got the H1B receipt notice, same employer, looking for a change of status. Do I need to go outside USA? Well, first of all, if your employers filed for a change of status, that should come along with the H1B approval. Assuming that they have not done so, you can go outside USA, or you can apply for change of status within USA if you are still on L1 status. It's like filing the H1 all over again, but change of status can be done within the United States. You can also go to any consulate, Canada, etc. Because you're a permanent resident of Canada, that's a real easy choice. Canada is definitely a good option for you. In both cases 2 and 3, so that is if you apply within USA or go to Canada, can they delay? Oh, absolutely. Absolutely. They can delay you. You can still enter with existing L1B if you have a visa stamp and they don't cancel it. That is definitely an option as well. So all these things are wide open for you. Press *5 if you have a follow-up question. *5. Okay. Oh, there you are. This one is from Connecticut. Okay, Connecticut, go ahead, please. I can hear you.
Hi, Rajiv. I had a question. What is the difference between this change of status H1B and the normal H1B that we apply on Quora? I know the change of status is L1 to H1. But when it comes to saying you have an H1, so what are there any?
Yeah, let me explain. Let me explain.
Sure, please.
The way this works is, when you file for an H1B, you are actually asking for either one or two requests. You have two things you are asking, either one or two. One, which is a must, is that Mr. USCIS, please consider me and adjudicate me to be eligible to receive an H1. So in other words, my job is professional, my employer gives me the right salary, job description is good. So USCIS says, okay, you are entitled to an H1B. That's one part. That is true for every single H1B case, whether change of status is requested or not. Clear? Are you clear?
Yeah.
Okay. So first thing is a determination that you are eligible for H1. That is common to every case. Second thing, which can be changed, is change of status. So let us say you are on L1 or F1 or H4. It is your choice to request the USCIS to give you change of status, converting you from F1 H4 L1, F1 H4 L1 to H1. And that is done within the United States. Normally, when we file for H1, we combine these two things. We say, please hold me eligible to receive an H1 and change my status to H1. However, the second part is optional. You can just ask for H1 and not ask for change of status. Why do you do that? Sometimes people want to stay on their L1 or their F1 or their H4 until they are ready to change to H1. At that point, they can do one of the two things. They can either go through consular processing, go outside USA, apply for H1 visa and come back. Now they are on H1 when they come back. Instead of change of status, they did consular processing. Or staying within USA on their L1 or H4 or F1 or whatever status, they can apply for change of status within the United States, refiling pretty much the same paperwork, and ask the government to change status from current status to H1. With me so far?
Yes.
Yeah. So in other words, each H1 has two components, one mandatory, one optional. Eligibility is mandatory, change of status is optional. So therefore, you could very well delay your change of status. Okay?
Got it. And if I have a H1, which is from a change of status, so that doesn't
Sorry?
certainly be the same.
No, I think you got cut off. You said if I have a change of status, what was that question?
Yeah, if I have a H1, that was from a change of status from L1 to H1.
Right.
So that, I'm equally eligible as other H1s, right?
Oh, absolutely.
So,
Absolutely. There is no...
change, switch jobs and do anything.
Yeah. You can do all of those things. It's just that your H1 doesn't kick off. It is approved, but it doesn't kick off until change of status is approved or visa is approved and you re-enter. Okay?
Okay, got it. Yeah. Thank you.
You're welcome. Good luck. Okay, so next question is from Krishna. Wife is under F1 OPT. Employer filed I-140 for me. Can I convert her from F1 to H4? Yeah, of course. Why not? And then you can apply for H4 EAD when your I-140 gets approved. You can do that. Absolutely. Star 5 if you have a follow-up question. I don't see any problem with this. Okay. Next question is from KJ Malvia. He wants to know what's going to happen with H4 EADs because he's heard some rumors that they're going to do away with them. Well, this is a regulation. Typically, a regulation, from what I understand, I haven't looked into the administrative law issues involved. But to me, it would take a few months at least to roll it back. I think if a regulation such as H4 EAD regulation, remember this is not like DACA, this is not an executive order which can be changed with a stroke of a pen. This is a regulation. The regulation can only be discontinued or changed through another regulation. And even if you expedite them, it will take a few months. How much time I can't say. It all depends. There are too many variables, but it will take a few months. And the EADs will become invalid only after the regulation is implemented, after going through the procedures. They can always, USCIS can always rethink whether they want to not scrap the regulation based upon the comments they receive. But with this administration, I see more of whimsy and by the seat of pants action than really considered, deliberate, thought out action. So I really don't know what they are going to do. In a normal environment, which we are not in, if you've been following my tweets, Trump is probably one of my least favorite people in the world. Not probably, he is. So I think he's done more damage to our country than anybody else could have. Nevertheless, for immigration purposes, his administration is especially poisonous. We just don't know what they are going to do. But fortunately, there is still rule of law. They can only go so far. I think it's going to take a few months. Star 5 if you have a follow-up question on H4 EAD. Okay. This is Marsra G. Applied for green card 2007, EB3, EAD since then, waiting more than 10 years. Now less than a year before my EB3 became current, I've been laid off. Well, you see, the good thing is when you get laid off and your 485 has been pending 180 days and your I-140 is already approved, you need to get a same or similar job or a job offer, even if not a job offer, and that will see you through to the end of the green card. A genuine job offer, and also you can form your own company. As long as you have an employer-employee relationship with your own company, you can actually do a green card transfer over, a portability with your own company. You need to get a lawyer to do this, just to make sure that all the known problems and the anticipated unknown issues are provided for, but you can do it for your own company also. Now, whether or not a job is same or similar, that is really a mixed issue of law and fact. That's not something you can decide or I can decide. In the meantime, you can be doing whatever you want to be doing. There's no law that prohibits you with the EAD to do any job. If you wanted to work at a gas station also, that's fine. But you must have a job offer or a job same or similar to your green card job when the government asks for it. That is important. Star 5 if you have a follow-up question. Mira99 says, if I put a credit freeze because of the Equifax security breach on my account, will it affect my green card? No, ma'am. It should have no immigration effect on H1B, green card, perm, I-140. I don't see how it could affect you at all. Go for it. Star 5 if you have a follow-up question. Star 5. Okay. Ilango. Working for a company O until September 2017. Layoff. You got a separation package, 2 months pay. Currently looking for a job within the 60-day grace period. I have 2 questions. Am I eligible for I-140 EAD with compelling circumstances? I don't know. I'll have to take your case step by step, look at health issues, look at job issues, look at family issues, all of those combined. Just owning a house is one of the factors, but not the only factor. If I file a job within 60 days, you don't have to provide the recent 2 months pay stubs if you're covered by the grace period. Look, this grace period is a little tricky, okay? The way the grace period works is, first of all, you must be laid off, which you are. Second, your I-94 must not be expiring within those 60 days. If your I-94 is expiring within those 60 days, then your grace extends to the I-94, not all the way to 60 days, okay? So, you can also look at our frequently asked questions and my blog entries on applying for a B visa, B1, B2 visa, to maintain status while you look for a job. Star 5 if you have a follow-up question. Last question, after which we'll take new questions, today was, I have a question regarding H1B. If company applies for my cap exempt H1B with a start date of January, it gets approved by the end of October. By the way, premium processing has already opened, so you're okay. For quota cases, they have opened, not for all categories, but quota cases, physicians, non-profits, they've opened it. Can I change jobs before January based on the approved H1B that has a start date of January? Well, another one of those issues which has been up in the air because government has not been meticulous enough to give us something in writing. But this is my understanding. My understanding is, if your H1 and your change of status is approved after October 1st, until October 1st, they don't revoke your H1. You can change, you're now exempt from the quota, you can go anywhere you like. If they revoke it before October 1st, which is not your case, then you are still subject to the quota. Or if you get no change of status and you don't get a visa stamping done, you are still subject to the quota. In your case, you can change your job before January. I think, now this is where it gets tricky. I think as long as they don't revoke your H1 before your second H1 is filed. Ideally, it would be great if the second H1 can be filed before they and approved before they revoke your first H1. But if that's hoping for too much, I think you are reasonably safe, from what I remember based upon our conversations with the USCIS, that as long as the second application gets filed, it's after October 1st, second application gets filed before the first one is revoked. Okay, I would like it to be approved before it is revoked, but if it is at least filed, I think you are safe. *5, if you have a follow-up question, *5. Okay, we have one follow-up question, also from Connecticut. Go ahead, please.
Yeah, hello.
Go ahead, please.
Yeah, so basically my question was, once this new H1 is approved with the start date of January, so can I use that H1 in October to switch to a new job?
I just answered that.
Taking a scenario where,
I just answered that question. Yeah.
okay, so I'm able to do that.
Yes, as long as before your H1B is revoked, the second one is received by the USCIS. Better still, if it is not revoked until the second one is approved. Okay?
Okay. Yeah, so basically the new job, they have to apply for the H1 and they have to
That's
before I...
that's correct. Okay? Good.
Perfect. And one other question, is premium processing, it's not open for gap residents?
Only for quota
Like
cases.
certain ones-
Only for quota cases.
Okay. So I have to wait for October for that.
I think so.
Yeah.
Okay.
And once I have the change of status, is it mandatory to go out of the country and get stamped and come back? Or I can just...
You can, if you receive your change of status, you don't have to go outside.
Okay, no stamping is required.
No.
Mandatory.
It's only required when you travel outside USA.
Okay.
All right.
Thank you so much.
Oh, you're welcome. Good luck. All right, folks. Anyone has any question, press *5 on your phone. Anyone has any question? 1, 2, 3, 4. Wow, that was quick. Okay. 1, 2, 3, 4, 5. Okay. 5 people have questions. Guys, I'm not going to answer any other questions. So 5 questions from 5 people is all I'm answering. Very good. These 5 are locked in then. Let us begin with the first one. You logged in the earliest. New York, go ahead please. New York.
Hello sir, good afternoon.
Good afternoon.
I have an L1A, total 7 years visa expiring in January 2019. My green card was filed in EP1C. I-140 is under process from Nebraska. Priority location, July 2017. My company has agreed to file concurrent I-485 so I can speed up my case. My family is in India and will stay back due to some personal reason until July 2018 next year. I have 2 questions. First question is, should I delay in filing I-485 until January, February next year 2018 so my family can file I-485 when they are back in US in July 2018 before my I-140 gets approved and I-485 gets approved? So at least processing can start on my side on the health background check and other filings, and I can save some time. Or should I file my 485 now, but don't file adjustment of status when priority date becomes current, and once family is back in July 2018, then I will file I-485 first, and then adjustment of status.
Hang on. Hang on. I-485 is adjustment of status.
Okay.
There's no difference.
So-
It's the same concept with 2 different names. So once you filed for 85, you applied for adjustment of status. Let me make it simple for you. Between now and January, there's not too much difference. It is highly unlikely, not impossible, but highly unlikely that your green card will get approved before January when your family returns. The only risk is if your green card by some chance gets approved, they will not be able to come back. You'll have to convert them to consular processing, and they could be separated from you for 8, 10, 12, 14 months while they wait for their file to go to the consulate. So if you get approved and they have not yet filed, there's separation. The risk of not filing now is the dates could slip back again, and then you would have no opportunity to file 485. Are you with me on both these things?
Yes, sir. But the only thing is they will be coming next year, July 2018.
Oh, next year? I thought you said January 2018.
No, the thing is,
Okay.
the question
Why-
was slight delay.
Hang on. Why don't you do this? Why don't you do this? This is the smartest decision you can make in my view. If I were you, I would file my I-485 right now, and I would file for their consular processing right now. Okay. What does that do? That means you have already the 10, 12, 14 months of separation. By the time July comes along, you've already spent 8, 9, 10 months of that. So even if your 485 gets approved, they'll be with you within 4 or 5 months. Okay. And if in July your 485 is not approved, they come back, they can right away apply for 485. Converting from 485 to consular processing is 8, 9, 10 month process. Converting back to 485 is 0 days.
Yep.
Okay?
So, how much time it approximately takes for I-130 and consular processing approval for immediate relatives?
I-130.
Yep.
Where does I-130 come from? That's not what I'm talking about. I'm talking about following to join. Do some research on this. I don't have time to go through it in a 5-minute conversation, but write it down. I am suggesting file your 485 now, convert them to following to join consular processing. If they happen to come back before your 485 is approved, you can immediately file their 485, no problem. That is my suggestion, okay?
Okay, sir. Thank you.
Good luck.
Thank you.
You're welcome. Oh, I'm trying to, okay, let's put this down. Alrighty. Why can't I mute it? Okay, here we go. Let's go to Pennsylvania. Pennsylvania, go ahead, please. We can hear you. Pennsylvania.
Hi Rajiv, good afternoon.
Good afternoon, sir.
I have one question. I'm currently on H1B Visa and I have approved 140 and it's more than 180 days over.
Good.
If I get a PR in Canada and I move to Canada and work for, there is a two situations. Work from Canada for the same employer who filed my GC in USA, or I can also work for employer in Canada. So my question is, when my 485 becomes current, do I need to be physically in USA to file my 485?
You can always come through consular processing. You can convert your case to consular processing if you want. There is an additional form that has to be filed, and your lawyer should be able to take care of that. It is not required that in the interim, while you're outside, you must keep working for the same company. As long as the company who sponsored you is holding the job open for you, it doesn't matter what you do in the meantime.
Okay, so do I need to maintain my H1 status
You-
as well as
you-
I'm in Canada?
you do
Or
not.
Not needed.
You do not.
All right.
So-
okay, thank you, Rajiv.
You're welcome. And I repeat once more the bottom line. You can move to Canada, work for the same company or any company, we don't care. You don't have to maintain the H1. Convert your green card to consular processing so your file, when your date becomes current, gets moved to Canada. You will interview and come back on a green card as long as your employer is holding the job open for you. Okay?
Okay, thank you very much.
You're welcome. Good luck.
Thank you.
Let's go on to Florida. Florida, go ahead, please. Florida. Florida.
Hello.
Yes, sir, I can hear you. Area code 321. Go ahead.
Yes. So actually, I received an H1 RFP stating that my role does not need a bachelor's degree or master's degree based on some handbook he mentioned. So the following questions are: he said, justify your role based on your education and based on your pay. So actually, I feel like mine is a technical work. So based on the H1 RFP, I see that he haven't read my resume or somewhat. So what
Okay,
can we do in this
hang on,
situation?
hang on. First of all, the topic of proving that the job requires a bachelor's degree in a specific subject, and two, that you have that degree, is something I can write a book on. It isn't something simple to explain or to understand. Number one,
Okay.
because I'll give you an example. The handbook that you're mentioning is called Occupational Outlook Handbook. Okay?
Yes.
The OH says, for example, for a programmer, it says many jobs require a bachelor's degree. So government says that means many jobs don't. And if you don't require a bachelor's degree, then prove that your job has certain features that bachelor's degree is essential. So your lawyers have to work very, very hard to cover 4 different angles: industry standard, employer's practice, how complex is the job, etc., to be able to prove. Any one of them is enough, but I usually cover all 4 of them to prove that the job requires a bachelor's degree. A lot depends upon the job description, the nature of the job. For example, if you are sitting, are you a technical guy, sir? Are you a technology professional?
Yes.
So let's say you are sitting doing Visual Basic Microsoft Access development. It's going to be hard for me to prove that you are a programmer who requires a bachelor's degree. But on the other hand, you are working with distributed databases, Hadoop, cloud-based technology, cybersecurity. I think I can prove that a bachelor's degree is required. Okay? So it's not a question I can answer in abstract. It's a very concrete, fact-based question. Another example is, if your employer is a furniture outlet with 3 employees and you are doing paradox-based, DBase-based development, old technologies, I think it's going to be hard for me to prove that that programmer is a bachelor's degree professional. But on the other hand, if that outlet is doing not only their own work, they're also developing point of sale software, and you are part of a team that is working on developing that software hardware combo, all of a sudden situation changes. So nature of the employer, nature of the job description, nature of the technologies being used, all of these are relevant. Okay.
Okay.
Good luck, sir. Yeah, go ahead.
Yes, thank you.
You're welcome. Okay. Some questions are not possible to answer without context, because it's like asking a doctor, how can I fall sick? Well, that's how we write books. But if you ask about a specific problem, that I have this pain in my knuckle, and this is my history, this is my blood report, somebody can give you a better answer. Let's go on to Maryland. Maryland, go ahead, please. We can hear you.
Hey Rajiv, this is just I have a question regarding the OPT. Right now, I filed for the H1, but I got the RFE regarding the saying the vendor letter, client letters.
Sure.
I mean, he said he because my client is not ready to give the letter, is there any way can we justify this one
Yeah, you see,
without?
basically, you have to submit something that proves 3 or 4 things. Number one, that your job description is described in detail and it shows that it requires a degree and you have that degree. Number two, that the employer-employee relationship is being maintained. And number three, that the project has a certain duration. So these things can be documented by things other than end client letter. If the end client is a government organization, it becomes a lot easier to prove it without the letter. If it is a large organization, there may be other things like work order, etc., that could be used. But it's difficult for me to comment. In general, I can say this: without end client letter, things are much more difficult, but not impossible.
Okay.
Okay.
One more question I have.
Hmm?
Is the premium processing is advisable or not? Because some forums, I read that there will be ways of the red flag if we go for premium processing.
I don't have any experience like that. In my mind, it's the same degree of scrutiny or the same degree of strictness, whether it is premium or non-premium.
Okay, first I will go for regular processing if I feel, because my OPT time ends like around January. At the time of December, can I go for the premium processing? I can expedite my
Hang on,
process.
you are subject to the quota, aren't you?
Yes.
You can't file before April.
Because, what does that mean?
Huh?
I did not get your answer actually.
You cannot file before April 1st.
But I already applied in this April, my H1.
Okay, so you're saying you are applying again? It's unclear what you're asking me.
No, just I want to expedite my process. This is the H1 regular process. Now they remove the premium processing, right? I can apply in the,
Yeah, you can.
I can.
You can. So what you're saying is I can let it stay non-premium or I can premium it. Are you asking me what is a better choice, or are you saying that you want to leave it non-premium?
Yeah, better choice. Better choice.
As far as the merits of the case are concerned, it's the same. I don't see any difference. Is it more approvable under premium, more approvable under non-premium? I think it's the same.
Okay, one more last question, please.
Yeah.
Right now, I have a RFE regarding my pay. My employer filed the H1 application for less pay, but I'm getting more than that pay. Is there any problem when I submit the pay stubs and all the documentation to the
H1B is a very heavily regulated visa. You are being hit by at least 3 government agencies' regulations. So it is difficult to answer any of these questions in the abstract. Without commenting about your case, I can tell you this: normally, getting paid more is not a problem. Normally. Okay? Well, good luck to you.
Okay, thank you so much.
You're welcome.
Thank you so much.
Bye. All right, folks. Did I just... Oh, hang on one second. I think I screwed this up. There was one more person with the hand up. I think California. Let me try this. California, did you have a question for me? California?
Hi. Yes, I'm online.
Yes, ma'am.
So my question is regarding an OPT denial, which I received on 18th of this month, but it was actually dated on 12th September.
Okay.
So it was denied on the basis that I filed for OPT after the 30-day recommendation period from the DSO.
Yes, ma'am.
But originally what happened was my DSO recommendation date was May 31st. I filed for it on June 14th. They received it on June 15th. But the filing fee was incorrect. paid, and they sent the demand draft back and asking me to send a new demand draft. By the time I sent them the new demand draft, it was July 7th, and they considered July 7th as the OPT filing date. So on that basis, my OPT was denied. So I am considering to file motion to reconsider, but at the moment I am out of the grace period. So question one was, would you have any idea how is the likelihood to be considered if I file motion to reconsider? And second is, if I can stay in US beyond my grace period while the motion to reconsider is under process.
I want you to send me your I-94
Okay.
to help@immigration.com. Okay?
Okay.
I'll give you a free consultation. I'll take a look. I think it's a very difficult case to win, but I want to look at the unlawful presence. So send me both your I-94 as well as the denial notice.
Okay.
Okay? I'll have my office call you. We'll set up a call for you. It's help@immigration.com.
Okay.
Okay.
And just one follow-up question.
Sure.
In this scenario, is it possible to have, if I got my F1 extended and graduation advanced, if that would help? Because,
Yeah. Yes.
I have a good relationship with my previous advisor as I did PhD with her, so I talked to her about this and she gave an option to advance my graduation.
Yeah, I know that works. I've seen that work before. But let's discuss it privately. There are certain elements here that I don't want to discuss in an open call. But yeah, definitely that is a possibility, and that does give you a ray of hope. If you are a PhD student, that becomes a lot easier. Okay?
Okay.
So we'll talk.
Sure, I will
Just send me your
Yeah.
I-94 and denial notice. I'll set up a call for you.
Sure.
Okay.
Yes. Thank you so much.
My
I
pleasure.
appreciate it.
My pleasure. Guys, I want to thank you, everyone, for being here. It's always a pleasure and a privilege. I've never forgotten that it is an honor to be able to assist you folks. We'll talk again in 2 weeks. Hang in there. Times are hard, times are odd. We know that. But this too shall pass. It won't last forever. We'll talk. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.